Conference Committee on House File 100, the bill to legalize adult use cannabis in the state of Minnesota. We have a busy agenda in front of us today. We are going to take action on several articles of the bill, including the articles related to licensing, criminal penalties, expungement, and we will complete our work on Article 6, which is the miscellaneous provisions. I think we have some motions here, starting with motions from Senator Port. Senator Port.
I move the adoption of Article 1 provisions as described and modified by the paired summary document.
Senator Port moves adoption of Article 1 as modified by the summary document, which was posted yesterday. Article 1 is the licensing section of House File 100. Discussion to the motion. Senator Rasmussen.
Thank you, Mr. Chair. And I was wondering, as we're talking about Article 1 and licensing, if either you or Senator Port can maybe talk about if we have a license holder in the future who, perhaps violates the medical claims section or violates some other part of Article 1 in the licensing agreement, what enforcement is in place, whether it's civil or criminal, to make sure that those who are holding the licenses, if they don't abide by what's in Article 1, that they'll face consequences for their actions?
Senator Rasmussen, I think that depends significantly on what type of misconduct or violation you're talking about. I mean, there could be regulatory consequences, there could be civil consequences, there could be criminal consequences, depending upon what kind of misconduct you're thinking about. So I don't know if you can be more specific in your question, or if you have a specific concern in mind. But just generally speaking, all of three of those remedies are available for different types of infractions. Senator Rasmussen.
Thank you, Mr. Chair. And yes, I would say my concern, and one in particular, would be on cannabis retailers who are making false medical claims. And even though in Article 1 we talk about that being not permitted, I'm just concerned that we don't have specific language on what civil or criminal penalties could apply. It seems like we're leaving up a lot to the Office of Cannabis Management to kind of figure that out, or I guess they could pull their license. But I just think that when I look through Article 1, I think that's something we want to make sure that we get right before these licenses are up and running.
Thanks, Senator Rasmussen. And I certainly am concerned about people making false medical claims. And of course, I think we do have a body of law about making false medical claims just in the world generally. And as you point out, there are regulatory consequences potentially for licensees doing that, including suspension or loss of license, depending upon the situation and what tools the office deems are appropriate for the conduct. Any further discussion to the Port motion? Seeing none, all in favor say aye. Aye. Opposed? Motion prevails. Article 1 is adopted as modified by the summary document. Senator Port.
Mr. Chair, I move the adoption of Article 4 provisions as described and modified by the paired summary document.
Senator Port moves adoption of Article 4 as modified by the summary document, which was posted last night. Article 4 is the criminal penalties section of the bill. Discussion to the motion. Seeing no discussion, all in favor say aye. Aye. Opposed? Motion prevails. Article 4 is adopted as modified by the paired summary document. Senator Port.
I move the adoption of Article 5 provisions as described and modified by the paired summary document.
Senator Port moves adoption of Article 5 as modified by the summary document that was posted. Article 5 is the expungements section of House File 100. Discussion to the motion. Seeing none, all in favor. Oh, Senator Rasmussen.
Thank you, Mr. Chair. I was wondering if either you or Senator Port could talk about how the expungement language in this bill would either compare or complement or conflict with the language that's in the public safety omnibus bill in terms of, I think it's called the Clean Slate Act. And if you guys could just maybe talk about how this would interact with that, if at all.
So thank you, Senator Rasmussen. I'll do my best, and then I'll look over at Ben Johnson and see if he thinks that I'm doing anything wrong or saying anything that's incorrect. But I think what is important to note, first of all, is that this bill includes expungement of felonies that go to the Cannabis Expungement Board, and I don't believe Clean Slate relates to felony expungement. Clean slate has to do, there is an automatic expungement of this bill that has some interaction with clean slate in that our expungements are following sort of a similar automatic process that the clean slate contemplates, but on a different timetable. The expungements in this bill of cannabis-related offenses that are not felonies and thus covered by the automatic expungement happens sort of as soon as possible. Clean slate happens sort of after a period of time upon conviction or final action disposition of the case. And I don't know, Mr. Johnson, if you have anything to add to that I screwed up or left out. Mr. Johnson.
Mr. Chair, members, I would say that's a very accurate description. I would only add to that by saying that the expungement provisions in here, particularly those related to the Cannabis Expungement Board, also allow for resentencing. The resentencing would be consistent with effectively the changes in the law, allowing certain felony offenses to be resentenced as a gross misdemeanor or misdemeanor offense if that was appropriate, if the board determined that was appropriate. That's not a power that's granted to the automatic expungement process that is in the Clean Slate Act. I think that's the most significant difference that Representative Stevenson didn't mention.
Any further discussion to the Port motion? Seeing none, all in favor say aye. Aye. Opposed? Motion prevails, and Article 5 is adopted as modified by the summary document. Senator Port.
I move the adoption of Article 6 provisions as described and modified by the paired summary document.
Senator Port moves adoption of Article 6 as modified by the paired document. These are the first two sections of Article 6 that we did not take action on Friday. These are compacting provisions related to adult use in medical cannabis. Discussion to the motion. Seeing no discussion, all in favor say aye. Aye. Opposed? Motion prevails. And Article 6 provisions as described and modified by the paired summary document are adopted. Members, we will now have a large number of amendments that we will consider. Senator Port, you have the A33.
I do. Mr. Chair, I move adoption of the A33. This is small technical changes as well as changes to the definitions to reflect decisions that were made elsewhere in the bill.
Senator Port moves the A33 amendment, which should be before everyone. Discussion to the A33 amendment. Seeing no discussion, all in favor say aye. Aye. Opposed? Motion prevails. The A33 is adopted. The next amendment, I believe, comes from Representative Hollins, the A126. Representative Hollins.
Thank you, Mr. Chair. I move the adoption of A126. This is an amendment that gives the Office of Cannabis Management the authority to make decisions on health and safety warnings and potency limits.
Representative Hollins moves the A126. Discussion to the motion. Seeing no discussion, all in favor say aye. Aye. Opposed? Motion prevails. The A126 is adopted. Representative Hollins, I believe you have the A127.
Thank you, Chair Stevenson. That's correct. I move adoption of the A127 amendment. This ensures employees with the knowledge and expertise needed to stand up this industry are able to seamlessly transfer to the Office of Cannabis Management.
Representative Hollins moves the A127 amendment. Discussion to the amendment. Seeing no discussion, all in favor say aye.
Aye.
Opposed? Motion prevails, and the A127 is adopted. Representative Hollins, you have the A20 amendment.
Thank you, Chair Stevenson. Yes, I move adoption of the A20 amendment. This finalizes membership of the Cannabis Advisory Council, ensuring that we have people and viewpoints in the room who are needed to advise the standing up of the industry.
Representative Hollins moves the A20 amendment. Any discussion to the A20 amendment? Seeing no discussion, all in favor say aye. Aye. Opposed? Motion prevails. The A20 is adopted. Senator Port, you have the A131.
I do, Mr. Chair. I move adoption of the A131 amendment. Mr. Chair, this stands up a new medical cannabis combination license. And members, this is a slightly big change that we've been working on throughout the year to make sure that we uphold three main principles while moving forward with the medical cannabis program in Minnesota as we adopt adult use. It was really core to everyone who worked on this bill that we continue to serve the medical patients across the state of Minnesota who need access to medical cannabis. It has also been a guiding principle that it is an even playing field, that anyone who wants in to provide medical cannabis is able to do so under the same rules as everyone else. And the third is that we have a 10-year relationship with medical cannabis in this state, and we want to ensure that the businesses that have continued to provide for medical cannabis are able to continue to do so seamlessly. And this stands up that new combination license, which allows for businesses that provide medical cannabis to patients in Minnesota to also be able to provide adult use based on the amount that they sell into the medical cannabis program. I think it's an elegant compromise that we've come to, and I encourage the adoption.
Senator Port moves the A131 amendment. Discussion to the amendment. Seeing no discussion, all in favor say aye. Aye. Opposed? The motion prevails. The A131 is adopted. Senator Port, you have the A35 amendment.
I do have the A35 amendment. Mr. Chair, I'd move adoption of the A35 amendment. This is an amendment based on local control. I want to thank the League of Minnesota Cities and the Minnesota counties for their continued partnership throughout the work of this bill to ensure that there is reasonable, responsible local control regarding zoning requirements and things like that. But they have worked with us to stay true to our guiding principle that there should not be outright prohibition in portions of the state. So I urge the adoption of the A35.
Senator Port moves the A35 amendment. Discussion to the amendment. Representative West.
So it has one every 12,500 residents or in the county or city. So for my county, which is like 600,000, I think, that's never going to be hit, I would assume. But for a city, one concern about this, I would prefer the old language for what that's worth. But we also have to make sure these businesses are competitive. So allowing the lower, in the first and second class that was in the Hochschild amendment, allowed for a little lower threshold, particularly for cities like Blaine and suburban areas. And I believe that's important because, yes, we want to make sure they're there, but too many means these businesses will have a very, very difficult time, and then people will have more than they would like. Because one thing, as you know, I'm supportive, but I've heard we don't want to be Denver. So I know there's no changing it, but this is pretty disappointing to see that this is where it came from. I think Senator Hochschild had a great proposal in the Senate that I wish we could have kept.
Well, Representative West, I will respectfully disagree with you. I think that if you put this into context, under the language that was in the Senate file, for example, the city of Coon Rapids could have set a cap at 3 dispensaries under that formula. And again, there's nothing that requires that. A city could decide to allow more, but they couldn't decide to restrict it further than that. That was the Senate language. The House language, or I shouldn't say that, the language in the A35, by contrast, would allow Coon Rapids to set a floor at 5. So I don't know that the difference is as huge as you are articulating. There's a compromise here between a House position, which of course had nothing like this at all, and a Senate position which was a little bit more restrictive, and we found a comfortable middle ground that maybe isn't anyone's first choice, but that hopefully everyone can live with on the issue. Senator Rasmussen.
Thank you, Mr. Chair, and I'm glad that there will be, some element of local control and local limits in this bill. I think one concern that I have that I think we should hopefully revisit next year is it's my understanding with this adoption of this amendment and where the bill is likely headed in terms of Article 1, there won't be any local control when it comes to low potency retailing and licensing. And one of the concerns that I have with the low potency licensing is that it's really going to expose a whole new set of consumers to cannabis products who aren't necessarily seeking it out. We could imagine that at all the convenience stores, grocery stores, bars, restaurants. And so while for the higher potency products, I'm grateful that there'll be some limits and some local control. I'm concerned around how low potency could really result in cannabis in a whole host of retail locations in every city or county without much ability for the local units of government to regulate that.
Well, thank you, Senator Rasmussen, and I hate to be disagreeable, but I don't think it's accurate at all to say that there's no local control over low potency products. While the one for 12,500 provision doesn't apply, there are a suite of additional local control provisions in the bill that still pertain to low potency edibles, including the requirement of having a local license that can be revoked if a municipality finds that they're not complying with sale to minor provisions or selling illegal products, including a requirement that you comply with local zoning procedures, including, I think, a requirement that a city can regulate its location relative to a school or a daycare or a park. And frankly, there are other provisions in the bill that also relate to local control. So there's one specific provision, this that I was just discussing with Representative West, the one for 12,500, that doesn't apply to the low potency edibles. That's true, but there are many others that do. Senator Rasmussen?
Thank you, Mr. Chair, and I appreciate that. And yeah, my concern is that it's my understanding with this language being adopted and where the bill is likely to head that there will be no way for a city or county to limit the number of retailing locations that have low potency. And so that was the point I was attempting to make.
Any further discussion? Seeing none, all in favor say aye. Aye. Opposed? Motion prevails and the A35 is adopted. Our next amendment comes from Representative Hollins, the A128.
Thank you, Chair Stevenson. I move the A28 amendment. This expands the criminal background check required for a license to every person involved in the business and management.
Representative Hollins moves the A128 amendment. Any discussion to the motion? Seeing no discussion, all in favor say aye. Aye. Opposed? Motion prevails. The A128 is adopted. Representative Hollins, you have the A130 amendment.
Thank you, Chair Stevenson. I move adoption of the A130 amendment. This amendment updates the definition of a social equity applicant in the bill to properly reflect the timeliness around cannabis conviction.
Any discussion to the A130 amendment? Representative West.
Thank you, Mr. Chair. Representative Hollins, could you go slightly into more detail, please, on what the amendment does?
Representative Hollins.
Thank you, Chair Stevenson. Thank you, Representative West. I'm going to defer to nonpartisan research on this because I know that it was something that has been worked out over the course of time when I have not necessarily been involved in this. So,
Mr. Johnson.
Mr. Chair, members, the version of the social equity effectively definition that you see here is really a combination of some of the provisions that were in the House bill and some of the provisions that were in the Senate bill. In discussing the language that was in the House bill, there was some concern among the members that a reference to a cannabis-related offense was too broad. It allowed for the potential for someone to say they had a cannabis-related offense with something like a DWI or other offenses. And so there was a desire to limit it to only cannabis possession and cannabis sales. And you can see that that change is effectively in clauses 1, 2, and 3. All of the rest of this language was in the House bill. It's just been broken out into clauses really for easier reading purposes. Clause 4 is essentially identical to language that was in the House bill. There's been some slight cleanup within this language just to fix some terminology and make it technically a little clearer who we're talking about. And it would include service-disabled veterans as well as current or former members of the National Guard and any military veteran or other former member of the National Guard who had lost honorable status due to an offense involving the possession or sale of marijuana. Clause 5 was originally in the House bill and remained in the Senate bill. There was some changing in the House bill. This is taking the Senate language on this with no other changes. And finally, Clause 6, there was a reference to farmer definitions that was in the House bill that referred to federal law. There's been some national discussion about that federal law, and members decided that referring specifically to Minnesota state statute that had a nearly identical kind of concept was cleaner and clearer for practitioners in the state. Mr. Chair, that's the summary.
Senator Rasmussen.
Thank you, Mr. Chair. And a follow-up question for Mr. Johnson. Mr. Johnson, is the date of May 1, 2023 also new language that isn't in the House and Senate bills?
Mr. Johnson.
Mr. Chair, Senator Rasmussen, thanks for pointing that out. You are correct. My understanding is there was some question about wanting to avoid any sort of bizarre incentive for people to go out and obtain some sort of cannabis-related conviction. And so this is effectively backdated so that there's no fake incentive for somebody to go out and get a possession offense.
Thank you, Mr. Chair, and thank you, Mr. Johnson. Yes, I think that's an important addition in this amendment to make sure we're not incentivizing, people to break the law and get kind of bonus points towards their application. So I think it's important that we have a cutoff on that.
Further discussion to the A130. Senator Olmo-Verbate.
Thank you, Mr. Chair. I just think this is fantastic that we're defining the social equity applicant this way. It's so important throughout this bill that the folks who have been most harmed by the prohibition are actually able to access this market. And I think just clarifying that those who have received those offenses for possession or sale, looking at specific census tracts and neighborhoods that disproportionately have experienced that enforcement are really, really key. So I'm really excited about how this has come together and hope that, again, the folks who have been most harmed are able to participate in the market as soon as this is legalized.
Any further discussion? Seeing none, all in favor say aye. Aye. Opposed? Motion prevails and A130 is adopted. Representative Hollins, you have the A27.
Thank you, Chair Stevenson. I move adoption of the A27 amendment. This provides further data classification for things like investigations.
Any discussion to the A27 amendment? Seeing none, all in favor say aye. Aye. Opposed? Motion prevails and A27 is adopted. Senator Olmo-Verbate, you have the A34 amendment, I believe.
Thank you, Mr. Chair. This amendment sets final canopy sizes for licenses and allows the OCM to adjust canopy size to ensure demand is met. I know this, as well as the next set of amendments, are due to some conversation that we've had with folks about just sort of getting into the market.
Representative West.
Thank you, Mr. Chair. The A34 is a very good amendment. One of the biggest problems of the bill was you couldn't really operate a cost-effective business. Now, I would love to see it be even more increase into the canopy sizes, but this is something that was crucial to be done. Glad to see it got done, because particularly a mezzo business license can now operate competitively as they could in many other states. The way the bill was designed further, prior to this, it was going to be very difficult to have a low-cost product, which is crucial to getting rid of the black market. So I am vehemently in support of this amendment.
Further discussion to the A34. Seeing none, all in favor say aye. Aye. Opposed? Motion prevails and the A34 is adopted. Senator Olmo-Verbate, you have the A133 amendment.
Thank you, Mr. Chair. And this is just looking at mezzo businesses to allow them to grow and possess the medical cannabis.
Senator Olmo-Verbate moves the A133 amendment. Discussion to the amendment. Seeing no discussion, all in favor say aye. Aye. Opposed? Motion prevails. The A133 is adopted. Senator Omo Verbatim, you have the A134 amendment.
Thank you, Mr. Chair. We had a number of labor peace agreements in the bill, and this is just making sure that those apply to low-potency hemp manufacturers.
Senator Omo Verbatim moves the A134 amendment. Discussion to the amendment. Senator Rasmussen.
Thank you, Mr. Chair, and a question for Senator Umu Verbatim. Senator, could you explain the rationale for why we want to have a labor peace agreement for these manufacturers in order to obtain a license?
Senator Omo Verbatim.
Thank you, Mr. Chair, and thank you, Senator Rasmussen. I think these are really important just to make sure that there aren't disruptions that are going to get in the way of us, ramping up this market. But I would also defer to Chair Stevenson and Chair Port. I know they've been leading a lot of these conversations with folks on the importance.
Senator Rasmussen.
Thank you. And I just, with this amendment, and again, when we talk about disruptions to the market, I just want to remind people that we're talking about recreational cannabis, and in this case, low-potency edibles. This isn't airlines. It's not the defense industry. And so I guess, I just have concerns about having in state law a requirement to get a license that you basically have to have an agreement with a third-party labor organization. And I just have concerns around us doing that here in this bill because to my understanding, I don't know if we do it anywhere else in state law.
Any further? Representative West.
To Representative Senator Rasmussen's point, this also is going to open, there's already labor peace agreements in the bill, and I guess we can stomach those, but this is going to open up to serious litigation that we've seen in other states that require labor peace agreements. And a low-potency hemp edible manufacturer is actually in a tough position in this bill because it is very expensive to make these products compared to a standard adult use edible product. You need to use considerably more plant matter and extract in order to make it. So they already have higher costs to manufacture these. They have more limits than the manufacturing other edibles, and this is just another burden on them. I think it makes it more difficult. It does make it more difficult to operate these. And it likely opens up to legal challenges. I think we should not accept this amendment, and I'd request a roll call on this.
Representative West requests a roll call. There will be a roll call. Further discussion on the A134 amendment. Seeing no discussion, Mr. Dockendorf will take the roll. The chair votes aye.
Stevenson, aye. Representative Hansen.
Aye.
Hansen, aye. Representative Hollins.
Aye.
Hollins, aye. Representative Kozlowski.
Aye.
Kozlowski, aye. Representative West.
No.
West, no. Chair Port.
Aye.
Port, aye. Senator Murphy. He's not here. Senator Umu Verbatim.
Aye.
Umu Verbatim, aye. Senator Pa.
Aye.
And Senator Rasmussen.
There being 4 ayes and 1 nay from the House and 3 ayes and 1 nay from the Senate, the motion prevails and the A134 is adopted. Senator Pa, you have the A129 amendment.
Thank you, Mr. Chair. I move the A129 amendment, civil actions to include products sold for on-site consumption. This adds products sold for on-site consumptions to the dram shop language.
Senator Pa moves the A129 amendment. Discussion to the A129. Seeing no discussion, all in favor say aye. Aye. Opposed? Motion prevails and the A129 is adopted. Representative Hollins has the A140 amendment.
Thank you, Chair Stevenson. I move adoption of the A140 amendment. This adds cannabis to the list of acts prohibited while under the influence, updates criminal penalties for illicit cannabis use, and adds cannabis to DWI substances.
Any discussion to the A140 amendment? Seeing no discussion, all in favor say aye. Aye. Opposed? Motion prevails and the A140 is adopted. Senator Umu Verbatim has the A141 amendment.
Thank you, Mr. Chair. So we talked a lot about expungement in this bill, making sure that that happens as quickly as possible. And it's really important that folks are able to access this information. So this will ensure that individuals are given information about access to expunged records for immigration purposes, and then provides immunity around expunging records. It also adds sales crimes to those that to be reviewed for expungement or resentencing by the Cannabis Expungement Board. Ensures the board is able to quickly, do this work.
Any discussion to the A141? Seeing none, all in favor say aye. Aye. Opposed? Motion prevails and A141 is adopted. Representative Kozlowski has the A37 amendment. Representative Kozlowski.
I move the A37 amendment, medical cannabis compacts, so that they will be able to be negotiated.
Representative Kozlowski moves the A37 amendment relating to compacting. Representative West.
Thank you, Mr. Chair. I'm wondering if Mr. Johnson could walk through this amendment as well for the public.
I'm sure Mr. Johnson, well, this amendment, Representative West, relates to compacting both in the adult use and the medical markets. And I think Ms. Painter can speak to it. Ms. Painter.
Mr. Chair and members, this amendment allows the governor, gives us language for adopting compacts with the tribal nations within Minnesota. It defines terms outside of Chapter 342 because these cannabis businesses will not be operating within that chapter. Tribal governments have their own medical cannabis and adult use cannabis programs. So you'll see here there's some definitions. There's the list of the tribal governments impacted or eligible for this. Nothing in this requires a tribal government to enter into a compact, but this states the terms of the compact, the purposes of the compact, and lays out some civil and criminal immunities for both medical cannabis and adult use cannabis.
Further discussion to the A37? Seeing no discussion, all in favor say aye. Aye. Opposed? Motion prevails. The A37 is adopted. Representative West has the A135 amendment. Representative West.
Thank you, Mr. Chair. The A135 amends the definition in Article 1 for artificially derived cannabinoid. The reason this is important is because I don't think anybody who was participating in the construction of this bill wants to make existing safe products that we legalized last year on the low-potency hemp market. They want those to continue to be available for sale. In many of those products, the way they extract the cannabinoid uses things like citric acid and light. And the way the definitions right now would make those processes illegal, as I understand it. And then now they would have to come up with entirely new products rather than just getting their existing products approved by the Office of Cannabis. This also gives flexibility for things as they change over time, because we know there will be new technologies and things like that. So I'd ask that we can include this language so that the hemp industry can more easily enter this new market.
Thank you, Representative West, for offering the A135 amendment. I would recommend a no vote on the A135 amendment. This makes a number of changes to definitions that would have cascading impact throughout the bill, potentially resulting in some unintended consequences. The definitions are very complex and have been worked out over the series of many, many, many weeks to arrive at this point, and I don't favor changing them at the 11th hour. So I would ask for a no vote on the A135 amendment. Representative West, are you?
Yeah.
Yeah, Representative West.
Thank you, Mr. Chair. This is one big frustration of how, not really as much this bill was handled, but if we're going to end early, it really, as the House leadership has suggested, these are the kind of things we should have more time to work out. And this is going to be damaging for the hemp industry, which I don't think anybody in this room wants to hurt, but this, in reality, it will hurt them. The one thing I would suggest is if we need to make it more narrow, if we can include this language in, as you've said in numerous conversations going forward, some element of this language, particularly around the practices already being done by the hemp industry. If we can look at that in the future, that would be incredibly beneficial because it'll be a while before the office is being able to approve products. So we might have more time, but the way it exists right now, I know of a number of hemp businesses that will have to be leaving the state because they can't operate as they have.
I think if I understood your sort of question correctly, Representative West, I'll say that while the time to make changes on this piece of House File 100 has passed, I am always open to having discussions about future legislation relating to any of these topics. Any further discussion to the A135 amendment? Seeing no discussion, all in favor say aye.
Aye.
Opposed? No. The motion does not prevail. The A135 is not adopted. Representative West moves the has the A136 amendment. Representative West.
Thank you, Mr. Chair. The A136 amendment includes naturally contained cannabinoids being allowed to still exist in a hemp edible product. This doesn't change the definition of hemp edible, which does have a very, very low threshold for cannabinoids that are not delta-9 THC, so this wouldn't necessarily open the door to them being allowed to operate who knows how. It just allows them some flexibility because this currently happens in the extraction process where there are still naturally contained cannabinoids in the products that they're selling, and they don't want to be punished when they really didn't go through a whole extra process to drive up costs on their product when it's perfectly safe as it is now, and this would just allow them to continue to operate as they are now.
Thank you, Representative West, for moving the A136 amendment. I would recommend members vote no on the A136 amendment. The change in definition, like the last one, I think could have unintended consequences, but in addition to that, I think that one of the thoughts behind the definition section of the bill is to be specific and precise and to foreclose some other options. And so I'm leery of opening the door beyond what is allowed in the bill. So I would ask for a no vote on the A136. Representative West. Seeing any further discussion? Seeing no further discussion, all in favor say aye. Aye. Opposed? No. The motion does not prevail. A136 is not adopted. Representative West has the A137 amendment.
Thank you, Mr. Chair. The A137 amendment allows for some variability, which in basically all food-grade products that are sold, there is some variability in what they say is in them and what is actually in them. This allows protection for the existing industry to say if it's off by a margin of error within the testing apparatus, that they will not be punished for that.
Representative West moves the A137. Members, I would recommend a no vote on the A137 amendment. I think that while there's some possibility that some flexibility could be offered by rule, by statute, I think our requirements are correct, and I think that it's important that we have very solid testing methodology to create good consumer protections. One of the rationales behind House File 100 is to ensure that people that are consuming these products can feel safe and comfortable about what's in the products. Any further discussion to the A137? Seeing none, all in favor say aye.
Aye.
Opposed? No. The motion does not prevail. The A137 is not adopted. Representative West, you have the A138.
Thank you, Mr. Chair. I have the A138 amendment. It was agreed that low-potency hemp edible products will be kept behind a checkout counter, which is very reasonable. But after we talked about that, I learned how many these hemp businesses currently operate where they're displayed in a case that is locked. I think being displayed in a case that is locked is just as safe, if not safer, than being behind a checkout counter. So I don't think there's any public safety risk, and this would be a reasonable thing that could save a lot of existing businesses significant time and money. And I think you have something to say about this one.
Representative West, you are correct in my prediction. Representative West, I think you have an interesting idea here and one that I'm open to. I would ask that you withdraw the amendment for today so that we can think a little bit more about it and discuss it. And we are going to have another meeting of this conference tomorrow, and if you would offer it again there, we can take final action at that time. But while I'm not ready to say yes, that I would support it today, I might be tomorrow, so I'd ask you to consider withdrawing the amendment today. Representative West.
Thank you, Mr. Chair. That is good to hear, and I also don't need to offer the A139, which is essentially the same thing. We can save a little bit of time, but this is something that I think is incredibly reasonable, small, not a big burden on drafting drafters, which is what my goal was here. So thank you, Mr. Chair. I withdraw the 138.
Representative West withdraws the A138 and also withdraws the A139. Senator Rasmussen, you have the A40.
Yes, Mr. Chair, I'd offer the A40, and I'm happy to describe it.
Senator Rasmussen moves
Thank
the
you.
A40.
Thank you, Mr. Chair. So this bill does a few different things in addition to legalizing and setting up a legal structure for cannabis sales for recreational purposes. One of the concerns that I think everyone in this committee has is about the black market emerging, the illicit market emerging. We've seen in some states such as California and New York where they've really struggled, even with a legal structure in place, to get the illicit market under control. One of the concerns, especially when I talk to members of law enforcement, that they have with this bill currently is that before we have legal, regulated recreational cannabis up and running, we will be meaningfully changing the penalties for possession and sales coming soon. There's some changes that are made in August of this year, and the others we make January 1st of next year. And so my amendment, it doesn't change any of the penalty changes, the petty misdemeanor for possession of under 2 ounces. It keeps that the same, so that'll go into effect August 1 of this year. But for all other possession and sales crimes that are currently on the books, it would push out that date to August 1 of 2024. And from the conversations I've had with agencies and with members of this committee, there's very low likelihood that any of these licenses will be out and up and running before August 1 of next year. And so this will help law enforcement be able to really make sure there isn't an illicit market that fills this vacuum in between the period of this bill passing and licenses being issued. So I'd ask for members' support of the A40.
Senator Port.
Thank you, Mr. Chair. Members, I ask for no vote on this amendment. I understand the reasoning behind it, but I think the cornerstone of this bill, as we have moved through the many committees that we have gone through, is that prohibition is a failed system that has not achieved any of the desired outcomes. This just means another year of criminalizing, particularly communities of color. It hasn't worked in the past. It's not going to magically start working this year. I strongly urge a no vote on this amendment.
Further discussion to the A40. Senator Rasmussen.
Thank you, Mr. Chair. And I would just, ask members to consider the fact that we will be substantially reducing the criminal penalties for sales and possessions, even if my amendment is adopted here today. We're just giving law enforcement the tools that they currently have to ensure that we don't have an illicit market expand during the gap between this bill passing and the legal licenses being issued. I'd ask for members' support. Again, this bill, even with the amendment adopted, will be making meaningful decriminalization in the cannabis world. And Mr. Chair would request a roll call on this amendment.
Senator Rasmussen requests a roll call. There will be a roll call. Representative West.
Thank you, Mr. Chair. I think Senator Rasmussen's amendment's reasonable because a big goal of ending prohibition is to eliminate the black market. Prohibition is what makes the black market dangerous, as we know, and this extra early legalization gives them more time to operate in a meaningful way to make some serious money. And when money is made in these kind of markets, people can get hurt and it is dangerous. Allowing this a little earlier, even though I'm, as you know, in vehement support of legalization, I think it's better to line these dates up a little bit so that we don't give an edge to the black market before the legal market has a chance to compete.
Seeing no further discussion, Mr. Dockendorf will take the roll. The chair votes no.
Stevenson, no. Representative Hanson.
No.
Hanson, no. Representative Hollins.
No.
Hollins, no. Representative Kozlowski.
No.
Kozlowski, no. Representative West. West, aye. Chair Port.
No.
Port, no. Senator Umu Verbatim.
No.
Umu Verbatim, no. Senator Pa.
No.
Pa, no. Senator Rasmussen.
Aye.
Rasmussen, aye.
With 1 aye and 4 nays on the House side and 1 aye and 3 nays on the Senate side, the motion does not prevail. The amendment is not adopted. Senator Rasmussen, I think you're doing the A42, not the A41. Is that right?
Correct, Mr. Chair. I just have one more amendment for us today. And so with that, I would move the A42, and I'm happy to describe it.
Senator Rasmussen moves to A42. Senator Rasmussen.
Thank you, Mr. Chair. So this amendment actually comes from a health professional, a doctor who had sent written testimony to this committee ahead of the hearing today, talking about the cannabis education programs that's highlighted in Article 6. And essentially here, the concern was, especially as this committee has discussed, the impact of cannabis, can affect brain development up to the age of 25. And so this medical professional just wanted to make sure as a part of the cannabis education programs that we were also including adults and not just youth. The current language just impacts youth. And then it would also ask the commissioner to consult with professional medical organizations. And in addition, as a part of conducting this educational program, would ask that the commissioner engage and consult with youth, young adults, seniors, and professional medical organizations. And so I think it just leaves a reminder there for the Commissioner of Health to be engaging a broad set of stakeholders and to be thinking not just about minors, but also adults as a part of the cannabis education program.
Senator Port.
Thank you, Mr. Chair and Senator Rasmussen. I am interested in taking a little bit of a deeper look at this with you. There are multiple sort of education programs and grants throughout the bill. I'm wondering if you would consider withdrawing your amendment today, having us discuss it this afternoon with the various ways the various programs interplay, and we could bring it up again tomorrow.
Senator Rasmussen.
Thank you, Mr. Chair, and thank you, Senator Port. Yes, happy to discuss, and with that, I will withdraw the A42.
Senator Rasmussen withdraws the A42. Senator Port, you have a motion, I believe.
I move the adoption of Article 1 and 5 and 6 as amended.
And I think you also want 4.
And 4.
Senator Port moves adoption of Articles 1, 4, 5, and 6 as amended. Discussion to the motion. Seeing no discussion, all in favor say aye. Aye. Opposed? Motion prevails. Articles 1, 4, 5, and 6 are adopted as amended. Senator Port.
I move to let nonpartisan staff make technical changes to, I can't read your handwriting, Mr. Chair.
Reflect the will of the
To
committee.
reflect the will of the committee.
Mine would be even worse. So Senator Port moves to allow nonpartisan staff to make technical changes that are necessary to reflect the will of the committee. Any discussion to the motion? Seeing no discussion, all in favor say aye. Aye. Opposed? Motion prevails, and nonpartisan staff are authorized to make technical corrections. Members, this concludes our agenda for today. As I mentioned earlier, I expect that we will meet tomorrow and take up the remaining articles, Articles 2 and 9, as well as potentially some other minor changes. With that, the meeting is adjourned.